Welcome to VPG's Virtual Water Cooler Chat Podcast, a platform that features professionals across a variety of industries and promotes growth mindset principles with a central pillar of championing the achievements of women. Our conversations explore a wide spectrum of backgrounds, experiences, and perspectives, creating a vibrant mosaic that enriches our collective understanding and strengthens our commitment to growth and empowerment.
Today, we're speaking with Dan Smith, a seasoned founder and global patent law strategist with a distinguished career at the intersection of law, innovation, and entrepreneurship. David has built a reputation as a trusted voice in intellectual property circles worldwide, and his nonprofit work further reflects a commitment to advancing access and awareness within the innovative ecosystem. An avid rock climber, pilot, sailor, scuba diver, woodturner, inventor, and patent holder, Dan approaches every challenge, whether in the courtroom, the workshop, or the open water, with the same curiosity and determination that defines great innovators. Let's get started.
Welcome, Dan. How are you doing today?
I'm doing very well, and thank you very much for inviting me for this.
Oh, no problem. So I'm the host of Virtual Water Cooler Chat, Ashley Chang. First thing first, can you share with our audience about the essence of Dan Smith?
I will do my best. I'm a patent agent. I am currently the president of the National Association of Patent Practitioners and do a lot of work advocating on behalf of patent practitioners generally, but also for patent agents specifically. Our organization is 50-50 patent agents and patent attorneys, and so we have that good opportunity to provide representation for the agents that don't typically have it in other organizations. So a lot of what I do and I really enjoy doing is finding those things in the communities that need to be rectified or identified as issues that we can fix and correct and use those as ways to elevate the community, the practice, both in the patent world and in the innovation world. And it kind of is foundational to a lot of what I do is that kind of practice.
What made you decide that you want to enter into the patent world?
I think like a lot of people, I didn't know that it was even a career that existed, especially on the patent agent side. So I had a couple startup companies. I started a rock climbing gym here in Boulder, Colorado about 20 plus years ago. I sold it and then used the money to go back to school for my technical degree, which is in physics and engineering. And during that process, I helped start another kind of high-end audio company doing amplifiers and cables and speakers. That was in 2008 when the downturn occurred. So was looking for opportunities then because the funding dried up. I had a climbing friend who was a patent agent at a law firm who had reached out. Really have to thank her for providing or letting me know about this career that otherwise I would have never known about, and is such a perfect fit for my personality and my interests in innovation and always being curious. And so I kind of stumbled into it by chance due to the connections that I had in other parts of my life. And that's a lot of what I try to also carry through the rest of I spent 18 years now, patent practice, and through NAP to really open up everyone's eyes to patent practice and what a great career it is and how it satisfies. If you're a curious person, if you're interested in technology, if you're interested in the law, you don't have to go to law school. You can become a technical specialist first, which is what I did, and then a patent agent, and then my career kind of developed from there.
That's really interesting. So you have built a career at the intersection of innovation and patent law. For someone who has never filed a patent, how would you explain what a patent practitioner actually does and why does it matter?
Right. Yeah, there's a lot of what a patent practitioner does, but most people think about patent practitioners doing is the drafting of the patent application and then the arguing with the patent office, arguing that idea as a patentable idea. Has value, it's novel, it's not obvious, things like that. But it kind of starts really at the interviewing with the inventors. So you're kind of capturing that idea, trying to understand this idea, and it requires a technical background to do that. So you have a specialty in a certain technology area at first, and then the patent practice is probably the best education you can get, because a lot of people start maybe in chemistry or in electronics, but as they grow their practice, their knowledge base and their expertise also grows as well beyond their original degree in chemistry, let's say. So patent practitioner listens to and identifies the novel and new ideas within the invention, and then has to translate that into patentees. They have to explain it and teach that idea through the patent application drafting process, such that the exam examiner can understand it. And then you can have a conversation with the examiner through office actions to move that application to an issued patent. One of the other ideas around this is the audience is not just the examiner, it is also the public. Patent application or an issued patent is an instruction manual for how to make and use the invention. Article 8, Clause 8 in the U.S. Constitution says that we are promoting science and the useful arts. By doing this patent application process, we are telling the public how to make and use the invention, and the inventor gets a 20-year monopoly in exchange for that. So that's another part of this idea, is that we are making public things that would not be public otherwise so that science can advance. We're standing on the shoulders of giants. We're trying to make sure that that knowledge is made public so that others can make it, use it, understand, and then build on those inventions, therefore, promoting the progress of science and the arts.
So NAVP is NAP, right? So NAP was founded in 1996 with just 19 patent practitioners and has since grown to hundreds of members across the US and around the world. As someone deeply embedded in this particular community, what does NAP offer that you simply can't get anywhere else?
Well, NAP is unique in multiple ways. Like I said before, we support patent practitioners, kind of 50-50 patent agents, patent attorneys. First founding member of NAP was a patent agent. A lot of patent agents are actually within the leadership as well. Me as the president, the vice president, the past president, vice president, and the vice president before that. So we have this system that really does recognize patent agents as full practitioners of law and as members. NAPP, the National Association of Patent Practitioners, is also purely patent focused currently. Unlike other organizations that are maybe IP focused, which brings in copyright and trademark and trade secrets, things like that, we're really focused on the day-to-day practice of patent practitioners and expanding opportunities for practitioners, providing educational opportunities for patent practitioners, and community for patent practitioners. So it's really one of the few patent practitioner-only focused organizations.
So you're an inventor and a patent holder yourself.
I am.
How does holding your own patents shape the way that you counsel and advocate for other inventors when it comes to navigating the whole patent system?
Yeah, it was actually a pretty big shift in my practice once I became an inventor. Seeing it from the other side, it's kind of like, it's not exactly the same, but like a parent or somebody getting parenting advice for somebody who's not a parent. Like it's the other side of the coin where you're actually trying to convey your invention to a practitioner. And then through the process for me, I realized how difficult it is and how much of a better interviewer I had to be to understand the invention, and not only the invention in a single form, but in all of its potential contexts. I've been a portfolio manager. I was for about a decade, managing kind of a global portfolio for an innovation lab. A lot of that practice has to do with creating patent families, and the first patent in that family is the parent. Everything grows from that patent. Interviewing inventors and being an inventor myself, making sure that I'm conveying not only the simplest idea, but all of its possibilities and all the avenues it can take was one of the biggest eye-openers for me, to make sure that when I capture ideas from inventors, I'm taking all that into consideration.
I see. So NAP's membership is almost evenly split between patent agents and attorneys, two paths that look similar from the outside but are quite different, actually. How do you explain the distinction to someone just entering the IP space?
Yeah, there's a couple questions there, I'm sure.
I like to just embed them all in.
Yeah, exactly. We'll just jump into all of this. You had said before, you use the right language, patent practitioner. And this is the language that the USPTO attempts to use all the time, but does not always use. But patent practitioners include patent agents and patent attorneys. Patent agents and patent attorneys are seen as exactly the same thing within the patent office. They have the same rights, responsibilities, duties, ethical responsibilities. One of the ways that we look at patent attorneys and patent agents is that a patent agent is a single jurisdiction patent practitioner, a single jurisdiction practitioner of law. And a patent attorney is a dual jurisdiction practitioner of law, at least one state and the patent office. In the same way that a dual jurisdiction lawyer, maybe that's in California and New York, is a dual jurisdiction. They are not more than the sum of their parts. They are two distinct jurisdictions that they can operate in. And the patent agent just has one. And it's a federal jurisdiction. It's patent law. So one of the things that a lot of people within the community don't understand, and this is one of the things we're trying to clarify, is that while a patent agent can't practice law outside of the USPTO, a non-patent practitioner lawyer cannot practice law within the USPTO. You must take the exam and you must meet the qualifications to get a registration number to do that. A non-lawyer or a lawyer non-practitioner is not able to advise on patents within the patent office, what's novel, what's patentable, and even operate within some of the drafting prosecution aspects of the patent office, like the IPR process, the ex parte review process, things like that, which are more like courts. They act in more like those ways. Patent agents can operate there, where non-practitioner lawyers cannot, unless they have special permissions they have to request.
Like a prohibition admission.
Exactly. Yeah, exactly right.
Yeah, I always find that very interesting that patent agent who holds a PTO reg number and attorneys can actually be counsel of record at the, IPR or PGR proceedings versus like in the federal courts, they cannot. They don't have a bar. I mean, they might have like an asterisk of some sort, basically saying that, for example, some attorneys in federal courts, maybe they haven't passed the bar or they only have special permission to practice under someone else.
That's right.
And so those are sort of like the disclaimer. So I always thought that it was really interesting because I have to look into whether a patent agent, because to me it's like you have to be an attorney to practice, but under the USPTO jurisdiction is quite different. So I thought that was very interesting. Yeah.
Well, and kind of going back to what we were talking about earlier, in an IPR process, patent agent can operate within the IPR process. If a non-practitioner lawyer wants to participate, they could be under the patent agent in that scenario, or if they do Vice as well, but they may actually have to be overseen by a patent practitioner, which would include an agent.
Yes. Okay. Well,
and actually on that point too, that it's interesting and it doesn't make a lot of sense to us. And this is some stuff that we're trying to clarify as well. In the courts, you don't have to be a patent lawyer to litigate a patent, which is a little strange because you have a whole area of law, which is incredibly complex. And it's actually stated in the Sperry case from the Supreme Court back in the 60s that they believe that patents are some of the most complicated contracts to negotiate and draft, that a non-practitioner lawyer can litigate those contracts in the courts, and they don't have to be registered or understand the technology or the patent law at all. I wouldn't recommend it, but it is possible the way the system is set up today. So it's very odd from our perspective.
I think that's sometimes why, like in a GP firm, a general practice firm, why they would either kind of collaborate with someone with a patent degree or maybe with a firm that is IP boutique to help them understand the patent litigation. So I thought that that's kind of interesting. Now, do you think that you can actually help us understand the actual exam that would actually allow someone to be admitted to have a PTO reg number? How involved is that process?
It's quite involved. And the pass rate is not very high. I think most recently it was in the 40s. And to even sit for the exam, you have to go through the normal processes for a state bar. You have to be of a high moral standing, things like that. But you also have to have a technical degree, or there's other ways to get into it if you've been in industry for a long time. But you can't take that exam if you maybe have a degree in political science or something. It's got to be physics, engineering, chemistry, biology.
Science.
Hard science, right? Because your job is to understand and then write about and teach scientific ideas. And ideally, they are new ideas as well. So the caliber of the intellectual capabilities of patent practitioners is quite high if you're successful at it, because you not only have to understand what exists in the past, but you have to conceive or completely understand novel ideas and then explain them to somebody else in your written document and in your arguments with the patent office when you're back and forth in office actions.
Yeah, it has to be novel, non-obvious, and all those requirements.
Exactly right.
So there's also, I think, is computer science one of the degree that actually allow you to sit for the bar?
It is, yeah. And there has been some changes with that over the years, but it's such an incredibly important aspect of patent law. And I think I've heard recently that 50% of applications have a software claim or component to them. It's just kind of permeates everything. And then on top of that, the new issues around AI, and there's a lot of activity in AI as well within the office, within the court systems, and then within also just policy within our government and also other foreign jurisdictions.
For someone who might be intimidated by like patent law, so to become a patent practitioner, what would you say to them that would actually inspire them and empower them to go forward and try being either studying for the test or getting into the space?
Well, for one, it's a fantastic career. Like I said, if you're a curious person, if you're interested in technology, especially the new cutting edge technology, it is incredibly satisfying. And I have often, walked around the electronics store and, I could see, oh, I did a patent on that technology. I helped this come into the market. And some of this very advanced technology has been really interesting. Quantum compute, quantum communication, blockchain, and, simple frying pans. Like it's a wide range of technology, really interesting technology, very well paying career, and it's also in demand. So I would highly recommend doing it. Joining an organization like NAPP is also really helpful. We've got a lot of support systems in place. And then there are also classes like the PLI has a preparatory course for the patent bar exam that I would highly, highly recommend. As most of the people I know, and myself included, utilize that course to prepare for the patent bar exam. So it's great for people who maybe get into a degree that they realize, maybe I don't want to be in the lab. Maybe I want to maybe look at a different way of pursuing a career. A patent career is a great alternative to that kind of lab work.
Do you collaborate with other organizations such as NCPP, National Council of Patent Practitioners?
Yeah.
I think that they just had an anniversary gala, and I couldn't not go because I was not feeling well. But I knew that you were there. Can you talk a little bit about how collaboration works with other organizations?
Yeah, it's one of the things I've been really trying to do since becoming president of NAP is to reach out to other kind of sister organizations to support each other. Again, our goal and my goal is to create a stronger community and have us support each other's goals and advocacy projects. So I was at the NCPP conference. Actually, was just emailing with them today about some more collaborations across some of our webinars and our annual conference, which is coming up in July in Seattle. Also trying to reach out to and have collaborated with AIPLA, the American Intellectual Property Law Association. ADAPT is another one, and trying to do that more with other organizations and just become more public as well.
All right, let's switch to something even more fun. You're a pilot, rock climber, sailor, scuba diver, woodturner. Do those pursuits inform how you think about risk, precision, and problem solving in patent strategy? Or is that a stretch?
No, this is actually a great question. And I didn't really think about it until you posed this, but I think a lot of my hobbies have to do with, or to excel at them, you really need to practice, preparation, constantly increasing your skills, constantly learning and developing.
Non-risk averse.
Not being risk averse, but how to minimize risk and how to assess risk and how to navigate risk. While most of those are more physical or a combination of physical and intellectual, the IP part, which is why I think I love it so much, is very strategic, especially the longer you do it and when you grow into more in-house roles, when you are trying to satisfy the goals of the company on a global stage. Strategic aspects of that and the navigating risk aspects of that make it an incredibly engaging career. So trying to look 5, 10, 15, 20 years into the future and understanding how a technology, not just understanding from its current form, but also how it's going to change over time and develop, and the obstacles that it's going to come up against, looking at those patents as a technology roadmap for a company and on a global stage with different rules in different jurisdictions. It's an incredibly complex system to look at and to navigate. And again, it keeps it very engaging. It's one of the reasons why I really love this. There's so much to the career and to patent practice that it provides a lot of opportunities to stay engaged, think very strategically, do the best to develop careers in patents, but also to support companies in patents, intellectual property, and innovation. Because intellectual property is not just patents, it is also innovation. It is how to grow a company and how to adapt a technology and evolve a technology over potentially 20 years. We're asked to essentially look into the future as far as we can and make sure that the patents and the inventions are protected for that entire time.
I once interviewed a rock climber. She's an Asian American woman. And the question that I asked her is when you're climbing up, were you scared? She was like, well, I really don't look down. You just keep looking up, right? So I wondered what led you to start rock climbing? Do you have the same response that she does. Because it's like, usually that's not the perspective is very different. So can you share with us? Because I'm not a rock climber and I'm not afraid of height, but I think that I have friends, actually, one of my former attorney, he is a rock climber. And I think one of the aspiration is to climb Mount Everest. I don't think that he has gotten there yet. He's also a pilot. I was like, oh, I don't know about scuba diving, but there's some of the things that he does, like parachute, hot air balloons, a whole bunch of things. You have a lot of those similar interests. So I wonder, like, how did you get yourself started? And do you actually really have a different perspective when you're engaging in those activities?
Yes. Engaging in those activities where you're pushing your own limits shows you that where you thought your limit was is not where it was. And maybe when you do find a limit, training it so you can surpass it is one of the most satisfying things I think that I can do. So pushing limits, finding limits, and expanding those and surpassing those is one of the things that I get from most of the activities I do and how I approach patent work and also the advocacy work that we work on. Identifying limits, identifying obstacles, removing those obstacles, expanding opportunities for patent practitioners. So I think it's a very similar approach to those. So specifically to rock climbing, definitely I have been scared a few times, but getting into a mindset where I can have that under control and still act in the way that I want or perform in the way that I want is also one of the satisfying things about rock climbing and flying and sailing. You get yourself into a situation, how do you get out of it? Like I said, so I started climbing in 1993, 92, started a rock climbing gym here and have climbed big walls and rock climbs, traditional climbs, bouldering, things like that. And each one of those try to push my limits a little bit. Some I'm not very good at, so my capabilities have a lot of room to grow, and others I've kind of maxed out or maybe reached my physical limits.
Let's talk about flying then.
Sure.
What is the furthest that you have taken your plane in terms of like the furthest distance?
I've done 3 pretty long flights. So I live in Boulder, Colorado, and I've flown from here to San Francisco for a conference. Another one, NAP conference in Minnesota. I flew from here to there, and then also to New Orleans. So 4, 5, 6 hours, 7 hours in the plane. Sometimes you got to stop for fuel and just to take a rest for a little while, or weather rolls in, you have to take a break. But those are pretty long distance flights, and those are things that I really enjoy. Again, it's kind of pushing the limits physically and mentally, making sure that everything is prepared ahead of time. And then you also have options. Like if something goes wrong, I can do this instead. Or I've got plan B and plan C and plan D, which again is back to the patent world. Like that's how a patent application should be drafted. You should have options. It's like a roadmap, like I said, a technology roadmap. There should be avenues that maybe you won't pursue, but at least they're in a patent application that you can then capture in a claim later in the life of the patents. So yeah, the flying is really great because it is very challenging. It's very mentally challenging. And it also, I think it's a good mental exercise to expand your kind of ability to think and multitask and do it under pressure and still perform.
Yeah, I think my attorney had actually flew overseas.
Oh, really?
I know. He's been to like Iceland, Germany, and definitely Canada. So I think before he was mostly doing like domestic flights, but then at some point he got comfortable. He was going overseas. So that was really interesting. I think he had like a TBM or something like that.
Oh, is he a German patent attorney?
He is US, but he speaks German. Yeah.
Okay.
Yeah.
TBM is a fantastic and amazing high altitude, very high performing plane. My plane's a little plane. It's 4 seats in it and they're shoulder to shoulder. So it's not a TBM, that's for sure, but that's great. And I have flown internationally once. I went to the Bahamas. It's just, I was at a conference and I just rented a plane and flew to the Bahamas, landed in Bimini, and then flew back. And just to do it because I had a half day off.
So people go to Enterprise to rent a car. You go rent a plane.
Yeah, exactly right. Yeah,
that's pretty awesome.
Yeah.
So some say everything rises and falls on leadership, and people don't leave jobs, they leave managers. What does strong leadership look like in the IP ecosystem, and how do we grow more of it?
Yeah, that's a really good question too. And there's so many different ways to look at leadership. Thinking about this, I thought about leadership within a company and leading people. I think one of the things I've learned in my career and try to emulate is leading people by elevating them, by increasing their capabilities abilities, by elevating them in their careers and in their career tracks. I've seen some leaders that will get upset when an employee leaves because they go on to bigger and better things. And I think it's probably it should be a compliment that you've done such a good job with your employees that they have been able to take the next step in their career.
Yeah, spread their wings.
Exactly, spread their wings. That's exactly right. When it's also you've created stronger people within the community that you have connections with, and patent practitioners and lawyers generally, they move around quite a bit. And having those connections, maybe they move into a company that you need to have a relationship with. If you have a good relationship with that person, it's incredibly valuable, and it makes your job and your career better as well. When you do this well, you look after each other, and that's what I kind of hope I have been able to do.
One of the things that I wanted to share is that I'm at the Unified Patent Administrative Law Conference at the American University in Washington.
Yeah, I spoke there a few years ago.
Yes. So when you're talking about leadership, so most of the time, so I come here in support, and then I also brought one of my team member. She's the creative engineer, 24 years old, very, very soft-spoken, introvert, but she studied kinetic imaging at university. That's a new media. So basically social media and stuff like that, right? I am in the study room having this conversation with you while I've given her the instructions of taking pictures and videos. I gave her all the equipment, and she was like handling this. So it's really interesting to see her, like, even when I was in there earlier, she was like, actually, I need to go up to the table. I said, well, you need to take this person. We need to have some pictures of this person and that person. And usually I would think for someone that is introverted, it would be very intimidating for them to just kind of walk around the conference to take pictures and video. But I've delegated that task with her, and then she's handling this. So I think that's one of the things that I really, really do enjoy, having younger people on the team. I've actually had someone that actually said to me that, well, the reason why you have so many young people is because you don't want people to question you. I'm like, have you talked to any young people lately? They question you constantly. Yeah. So I just thought that was really interesting. And that's one of the things that, I have my own company, Virtual Patent Gateway, not Virtual Water Cooler Chat. That's the podcast. But it's been really amazing to basically, hey, here's a problem. Can you figure out what it is? And then send me, and I will do like review and edit. I'm not a patent attorney, but I've worked with patent attorney for almost 25 years. Yeah. So it's been like really interesting. And I also do not have a hard science degree. I am a political science and East Asian languages and cultures. Yeah. And so far, they have not kicked me out of the field yet. Instead, I just started having my own company. It's been 6 years. So one of the things that I really enjoy is talking to people and having the podcast. And so I'm really glad that we finally have a chance to talk.
Yes.
It's been a pleasure. And if there's anything that you want to say before we close this particular episode, what would you like to say to basically help people from the outside world understand about NAP and also about the patent space?
Yeah, there's so much. We have a couple unique things that we pursue that no other organization is pursuing, and that is some of our advocacy projects. So within NAP, the patent practitioner harmonization work that we do is very unique, and also the trademark agent work that we're pursuing now. So patent practitioner harmonization is, and actually may relate to you directly. Currently, the way that the rules of professional conduct are set up within the USPTO, patent agents and patent attorneys are seen as the same thing. The patent office says that patent practitioners generally can partner with each other, can share fees, things like that. They buy and sell firms. They basically took the ABA's model rules of professional conduct and then adopted those within the USPTO. Those are the same rules that the states adhere to. So as a non-patent practitioner lawyer, and where are you barred?
I'm not barred. I'm a paralegal case manager. So I support patent practitioners that has a PTO reg number. So I do not do anything that is unauthorized, obviously. And so purely supporting in filing, and everything was signed by PTO reg attorney or agent. Mostly, actually, all of them are attorneys. I might have patent agent, but they are usually under the supervision of the attorneys as well, even though they can actually practice. That's kind of how my areas are.
And so where is your firm located? Are you in DC or is it widespread?
I'm actually remote. That's why it's named Virtual Patent Gateway, but I'm located in Virginia.
Virginia, okay.
Northern Virginia.
And so the state bars have taken the ABA, the American Bar Association model rules of professional conduct, which kind of outline the requirements to be ethical, essentially. Yes. And so the patent agents are bound by the same rules as lawyers in any state. So this one project
paralegals.
Yeah. So exactly right. So the partnering issue is one of the ones that we're trying to rectify. Right now, patent agents have been in many court cases, and the USPTO sees patent agents as practicing law. So they are licensed practitioners of law. And I have a whole talk that we could go into about why patent agents are essentially lawyers and have actually been called lawyers by a couple court cases, for example, in Texas. So we're trying to remove these barriers and misunderstandings and misinterpretations of the state rules of professional conduct about lawyers not partnering with non-lawyers, not sharing fees with non-lawyers, because essentially patent agents are licensed practitioners of law and are lawyers in all but name. So that project is one of the main ones we're working on. The U.S. used to have a trademark agent before 1955, and most other countries actually have this as well, in Canada and Europe and the U.K. And so we're looking to reinstate the trademark agent and have been working with senators, with the states, and with the USPTO to rectify this as well. A lot of projects that we're working on, and we probably don't have enough time here to talk about it, but
especially when they try to get me.
Yeah.
So thank you so much. That's a wealth of information. I will be looking out for what great things NAP is actually doing, and really happy that we finally connected.
Finally, yeah. Thank you so much. Really appreciate taking the time. And if you want to talk again, let me know. I'm happy to dig into specific projects and whatnot as well.
Great. Thanks so much.
Thank you, Ashley.